Tonight, we begin with developments that I think really offer a kind of a contrast in this period of legal reckoning and accountability that we've been talking about together, because we were thinking about this for tonight's show. If you look at all the prosecutors and all the investigators and all the probes that Donald Trump has faced, including squaring off against big-time experienced investigators like prosecutor and former FBI Director Mueller, there were crimes found. There were issues that ensnared Donald Trump's aides. But even as the now 2-year probe of a very public insurrection and attempted coup has grinded on and not reached Donald Trump or most of his top aides, there are more clear signs and steps that show one prosecutor on a different fact pattern in a different case has proven able to legally get farthest against Donald Trump and make precedent. I am talking about the New York District Attorney Alvin Bragg, who actually only recently took over that office. He has less experience as a prosecutor or in this role, and certainly less power than the leaders of the federal Justice Department, like the current Attorney General. But it was Bragg who put Donald Trump dead center right there, as you see, at that infamous arraignment table, the first criminal indictment of anyone who's ever been a president of the United States. It is DA Bragg who is now gearing up to go forward after that arraignment, that ignoble day for Donald Trump as a defendant, and actually put Donald Trump on trial. And it is Alvin Bragg who is doing all that methodically, moving forward, while these other probes that we sometimes hear about in Washington or down in Georgia continue to basically take a lot of time without resulting in anything that seems like a coup-related indictment of Donald Trump. We hear about process and delays and their witnesses. And it is DA Bragg who is making waves tonight. That is the context for the story. I wanted to kind of remind everyone that it's not nothing to be a local DA and indict a former president. But now Bragg's making waves and going so far that even some Trump critics are wondering in legal circles what he's up to, because it's a new crackdown taking aim at Trump world. The DA is trying to pressure the convicted Trump money man who already did some time in Rikers for fraud. That's former Trump Organization CFO Alan Weisselberg, who basically got convicted, went to jail, but never actually flipped on Donald Trump as a cooperating witness. And here's the big story. Bragg is eyeing a new indictment, new perjury charges against Weisselberg if he won't cooperate further. And that is an effort in the ongoing campaign to either get or bolster what this DA clearly thinks is existing, available criminal evidence against Trump. That is to say, you don't seek this kind of cooperation unless you have reason to believe that the guy knows something that he can provide. And this is the New York Times report you see there. And Bragg, well, he may be trying to turn over every stone, or he may think that Weisselberg still knows things that could even add to the affirmation case, the criminal case against Donald Trump. Indeed, it was only within the last 2 months, about just less than 2 months ago, when Trump was indicted and arraigned in New York.
Here's Donald Trump walking through the hallway. Let's listen to see if he speaks to reporters.
Will you come speak to us, President Trump?
It was Trump himself, in his own voice, pleaded not guilty.
So we now have it. Everything we've been talking about.
These are felony crimes in New York State, no matter who you are. We cannot and will not normalize serious criminal conduct.
That was last month, early April. It's not exactly clear from the new reporting what Bragg wants to learn from Weisselberg. But even though we live in this very unusual time, we kind of all know that, what we're living through, and the political echoes of this MAGA era, it is still striking that it was just last month that we had the first ever indictment of a former president, and it is Bragg driving this. The Times reports that the hush money case is moving ahead with Cohen as the star witness, while Bragg has been reluctant to charge Trump for his financial statements without Weisselberg on board. So this is a big deal because this is reporting that shows Bragg may do something to try to get evidence that could add charges against Donald Trump. And if you followed that indictment last month, you may remember there were people, lawyers and just regular people who follow the law, who said, gosh, of everything Donald Trump is involved with, ensnared in, accused of, this is the thing. Well, this reporting suggests one theory of the case, one possibility is that Bragg believes they have a case, but they can bolster it, what's sometimes called a superseding indictment. You get more evidence of more crimes, you add to it, because it's all in that same New York jurisdiction. This could be an aggressive move to turn another witness against Trump. It could also be that the DA's office, somebody in there who obviously has sway over Bragg, has convinced him that they really could use more than Michael Cohen. They want another witness to build a stronger case. That could even be a sign of concern about how a jury will receive the witnesses they have. So that intrigue and that New York Times reporting is going on in New York criminal court, and it comes amidst Trump's loss in New York civil court. The jury was just found him liable for sexual abuse and defamation in that case brought by E. Jean Carroll. And her lawyer says that may not be the end of it, that they won, that means something. But if he continues to defame her, which has been part of his campaign strategy, he did it at that big town hall, well, they may go after him again.
We were so proud to be in America and see democracy actually work.
The defamation, the calling you a liar, the exact same things the jury held him liable for the day before, he did again the next day on national television.
It's unprecedented for a person to have been held liable in defamation to keep doing the defamation. So there are not a lot of cases that we can look to for a playbook about how to do it. But suffice to say, I have a lot of lawyers who are very busy looking into this, and we are weighing all of our options.
Yeah, you heard it. Carol and her lawyer speaking to our colleague Rachel Maddow with that big newsworthy interview, and that news is still trickling out from it because we hear this a lot. Lawyers and judges do prefer to do things that are precedented. It's a big part of how the law works. But sometimes you have situations that are both unprecedented and still require action. That justice means making the new precedent. That's clearly what D.A. Bragg thought was necessary in indicting a former president. If he wins that case and uncovers and overturns a lot of evidence, he may be vindicated in the history books. If a New York jury rejects it, or they find that ultimately this was not the right case to bring as this guy runs for president again, maybe that precedent will not age well. We don't know yet, but what we do know is that he thought the evidence against Trump required making a precedent. When you look at that woman there who was found to be credible and honest by that jury, and she says, Ms. Carroll, that to vindicate her win, she may sue again. That is a new precedent. Her lawyer explaining that most people who pay out millions in defamation consequences don't just turn around and do it again. In law, they call that deterrence. But when you are dealing with someone who is hard to deter, the question is, do you fold or do you keep pushing harder? As we're seeing in more than one case, that is the test of this man who is still trying to be president again. And the Republican Party has largely continued to embrace that, while next week, if Ron DeSantis makes a certain type of announcement, they may have finally what they consider a conservative alternative to this indicted, legally avalanched, but presumptive or likely nominee of their party.